It is December 19th, 2025, and this is the Court Gallery. Ladies and gentlemen, I don't know what I'm doing sitting over here chatting in chat, but we're starting the show. Ladies and gentlemen, welcome to the Court Gallery. It has been a full day around the CourtTube community. There's just been tons of stuff going on. We're starting things off in Texas with Judge Stevens, who, quite frankly, had a very interesting case that kind of blew up towards the end. You'll see what happens. Then we're going to be moving on to Michigan with Judge Middleton, where we'll have a repeat set of landlord tenant matters that we've been following for quite a while. And then we're going to end with Judge Simpson and Miss Donna TOPE. And all I need to say is we're ending with Judge Simpson and Miss Donna TOPE. And ladies and gentlemen, it all starts right now.
Come forward, please, sir. And we now call 25 CR 329, the state of Texas versus Charles Darrell Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. You okay there, buddy?
Yeah.
All right. Earlier, you pleaded guilty to this indictment, which alleges the second-degree felony of burglary of a habitation. A pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, state?
None from the state, Your Honor.
And from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So we've got no less than 2, nor more than 10 years confinement. He could be placed on deferred or unadjudicated probation for up to 10 years. And he could also be placed on regular probation. I could sentence you to no less than 2, nor more than 10 years in prison, and then suspend that and place you on regular probation. But you've been on probation before, and that was revoked back in 2002. Then it looks like in 2009, you were sentenced to 6 months in the state jail for drug conviction. So that's 2 felonies convictions. And then we have a marijuana possession, which was regular probation. That's a conviction, illegal possession of marijuana, and that was in 98. And then 03, 30 days in jail. These are misdemeanor. Possession of drugs, 30 days of marijuana. Another in 2012, there were two of those in different. That's odd. Look at that. That's the same exact number. That can't be right. They duplicated that. So
That's true.
that's got to be an error. Looks like you have 3 prior misdemeanor convictions of marijuana,
Yes.
and then 2 prior state jail felony convictions. And all of these are the same thing. It's controlled substances. All right. Go ahead.
Your Honor,
You may go forward.
Thank you.
If you wish.
yes, please, Your Honor. We're going to ask the court to put him on probation, and we're going to let the court decide whether regular or straight is the court term of probation. Looking back at his criminal history, as you see,
His time, the credit, please. Thank you. Go ahead.
and like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out on the PSI, Your Honor, is in the statement of interested parties that the victim of the case, who I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation. So if the court was to give probation to this individual, this defendant, the victim is already on board with that, is okay with that. Also, the last sentence there, she says she asked the court to order the defendant not to have any contact with her in any way. If you were placing him on probation, you could make that an order and keep him away from her for up to, and I'm sure the court would do this, 10 years. Versus if you send him to prison, we all know that he's not going to do a full 10 years, and then the court would have no control over keeping him away from his Part at that point. I mean, she can go down and get a protective order or something like that, but it's out of this court's hands. But if we were to give him probation, then the court could order him to stay away from her and make it a condition, and that if he violates it, then he goes to prison for up to 10 years of his regular probation. And if the court defers it, up to 20 years. That would give the court a bigger hammer if the court wanted to do a deferred probation. You could sentence him to a longer time if he did violate probation. Also, I think they indicated some drug treatment. I think we can get him evaluated to see if drugs are still an issue. Like I said, I know there's a history of drugs, but the last one, like I said, was not, the conviction was in 2012. So I think that probation is probably the best in a case like this. That's all I have to stop.
And then the other side. Let me ask you, before we go forward here,
Yes.
I was thinking about some things, but everybody has reviewed the pre-sentence report.
Yes, sir.
There aren't any objections here. No, okay.
Yeah. I know that's
All right. All right, go ahead, Steve.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning. And he just starts beating her, ends up choking her out several times where she passes out, and she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this, and he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind if I call him as a witness about what that
Okay.
meant.
Okay.
Uh,
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct? Correct. Okay. You did go in the house uninvited, correct?
We went into the house.
Hold on. Hold on. Hold on. Hold on. It's all about what the facts are.
Yes, sir.
I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above date, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry. He forced his way is a violent act. Okay, let's correct the record. You weren't invited in. This says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't. What I'm getting at, I was getting to question him, is that he was there. They went in. It wasn't a situation.
He's saying the police are wrong in this report.
Well, the
Is that what he
police.
said? Well, let's come on.
Well,
Let's get
let's-
it straight.
Let's get straight.
Is this, nobody objected to this. That's what makes me
Because that's-
unsettled. I've got to make my decision on the facts. No one objected to this. This is here. He forced his way in.
Your Honor,
Is this wrong or not?
that's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His
Okay,
his
all right,
is
but
different.
that's what, well.
It's not, we can't
Well,
object
but
to what the police
you need
say.
to- If there's a big difference between what is being said here by the authority that wrote this and you, point it out to me.
Okay.
I mean, I do read this, but sometimes
Also, Your Honor,
these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
well, Your Honor,
Go
we
forward.
had the trial, and the defendant or the victim even testified to that. Okay, but his position is that, and I'm trying to get a question, is that he did go in uninvited, kind of forced a way through, but it wasn't a situation where he broke a window or broke a door or went in that type of way.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay, but Your Honor, sometimes with non-lawyers, they understand the difference between breaking into and going out without consent. I think
Facts
that's
are
what
the facts.
The facts are
That's
facts.
all I want. It's facts.
Facts are facts, but I think when you ask, did you break in, he's going to say no, because most non-attorneys deal with this don't consider just going in without
I've
permission.
done this for
breaking.
40 years. I know what you're saying.
Okay, all right. That's what I'm getting at. So I think that explains his version of it, that he didn't break into. I think that's going into it. Now, whether he went in with permission or not, I don't think he went in with permission. I don't think anybody believes that.
But what we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Okay. Well, I think the facts are, like I said, the facts are the
I'm a
facts.
fact finder.
He went in without permission and some bad things happened. I think there's no question about that. Okay. The question is in his report, I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him, when asking the defendant if he broke into the victim's house, the defendant said no. Okay. So I think that's the issue here, is I don't believe he broke into, meaning broke in a door, broke in a window, something like that. But he did enter. If they would ask, did you enter without permission? That'd have been a different question. Okay. So I just want to make sure the court that's correct. Okay. And it's not an objection to it, because that's exactly what all was said. We're not objecting to any of that, because that's true. But I think the court needs the explanation of that's the difference there.
And it goes, upon entering the residence this date, he began assaulting her and dragging her through the house by her hair. using his hands to strike her and threw her body about the room. Then used his hand at the front of her throat, grabbed her trachea, then squeezed her throat, cutting off her breathing and causing her to pass out. So does that look like he was invited and welcomed in there, or he snuck in behind her and immediately began to assault her? That's not forcibly entering.
When, Your Honor, there was testimony from the victim that he actually, he was in no way invited. In fact, he showed up behind her as she was going in through her garage and ran up on her.
Do you agree
and
with that?
Went into the house.
Yes.
Okay.
But I'm just saying that the phrase broke into, I think that I don't want.
We're semantics now. Well, I'm talking about he committed the crime of burglary and she was assaulted.
That's why I was.
Let's move on to what the points are. We're bogged down on how he entered the building, but it was for no good purpose.
It was not with permission. It was not for a good purpose, right? But it wasn't a situation where he broke into. I think so. I don't want the court to say that he lied here, because I think his version is that he didn't break into because he doesn't understand what the law says. Okay.
Wait, did he enter her home without her permission?
Absolutely.
Okay, so he trespassed. Okay, that's a crime.
I know. We're not saying that he
To
didn't.
get in, he committed a crime.
We didn't say that he didn't commit a crime.
Let's move forward.
Okay, all right. But like I said, I like to go back to the point where even the victim in this case indicated that probation would be good for him, or she would have no objection to it. And I still think that probation with a restriction to keep him away from her and all the conditions of probation to making sure he lives right would be good. I know he has violated probation in the past. However, in the past, it was a drug-related issue, and it's been quite a while since his last probation. So I think this is the type of case that this would keep him under the court's authority, keep him under the court's eye through the probation department. That this would be helpful for this both the victim and the defendant in this case.
So,
Your Honor, the victim here could have died multiple times. He passed out several times. And by the grace of God, she didn't end up dying and was able to escape. Who knows if she wasn't able to escape, and one of the times when she asked to go to the kitchen, what would have happened in the end. So sometimes we have to protect the victims also. In these type of relationships, we know they tend to want to be lenient on the defendants. However, that's a dangerous situation, and what he did was extremely dangerous and horrible. And with those kids, again, dropping them back off over there, and they have to see the house being completely busted up, knowing their mother has been strangled and beat. I believe, again, every bit of that 10 years is warranted in this case.
what would you like to say, sir? This is your time.
Before we tell Middleton the thing that happened,
What happened?
you going
Because he's saying something different than he is.
I went into the house without permission.
And then what?
Yeah, like, no price.
Then what? Oh, she punched you first?
No, sir. I grabbed her phone and she grabbed me and we started wrestling over the phone, basically. I had no intent to try to kill her or harm her or do anything.
Well, it says you dragged her through the house, used your hand to squeeze her throat, cut off her breathing, causing her to pass out. When she would regain consciousness, you would continue your assault and squeeze her again. This assault went on for several hours before she was able to escape her house, running to a nearby business where a citizen was able to contact the police for her. She sustained injuries in the form of abrasions, scrapes, cuts, and bruises all over her body. Are you kidding me? You're going to stand by what you just told me, that really nothing, you didn't intend to do anything, this was no big deal, in spite of what this says? You don't understand and appreciate the seriousness of what happened in this person's home where she's supposed to live in peace?
Yes, sir.
Okay. Here's another statement that I don't understand that you made to the probation office. When asked how you're going to do if granted probation, you stated, I'm going to do good. I'm not really a drug guy. Really? What are you? How many convictions do you have of drugs?
It's pretty.
Wrong. Do I know more about you than you do? No, in 98, you were convicted. 1 year adjudicated probation of illegal possession of marijuana. In 2003, 30 days in jail. In 2012, 30 days in jail, marijuana. In 12, 30 days in jail. In 2002, let's talk about the felonies now. 2 years state jail, probated for 5 years for drugs. That's 5. That was revoked and you received 6 months state jail. And then in 2009, 6 months in the state jail. 2000 and 1, 2, 3, 4 misdemeanor drug convictions, but you're not a drug guy. You don't have an answer to that.
No, that's
Because it's just nonsensical.
speaking of recently.
Oh, recently, you mean since you've been in jail? You don't use marijuana in
The
jail.
last 12 years, I haven't been.
Let me ask you this. This event, was this caused by drugs?
No, sir.
So this is the way you act when you're sober?
No, sir.
Yes, it is. Oh. Okay. Within this. Dead. If not, I'm going to find the defendant has pleaded guilty voluntarily. He is mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilt, your plea of guilty from State's Exhibit 1 admitted to your hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt, and I am following this agreement. The agreement is whatever sentence shall not exceed a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You can leave.
Ma'am.
You can leave.
You step outside, ma'am.
Step outside. This is what we call justice.
Yes, sir.
Your rich criminal history. You have a rich criminal history. You're held in contempt of court. Get her. She'll be. You can't make an outburst in court.
Get it.
You're going to be given credit for all time you have served, but you can't invade somebody's home and assault them.
Yes, sir.
And with your rich criminal history, we knew better. All right. Okay, anything else to add?
No, Your Honor.
That is all. You can't make an outburst in this court. You can be held in contempt of court up to 6 months, ma'am. Are you related to somebody here?
I'm sorry, sir.
Or that's okay. Are you related to somebody? Who do you know? This man?
Yes.
Oh, how do you know him? He's your brother. All right. You were here and you heard what this was all about, right? Did you hear? Okay. It's a very serious thing.
Yes,
And his criminal history was, but here's an issue when he gets out, the family needs to help with this. It's still a drug issue that he's struggling with. And he says he doesn't have a drug problem, but I think a lot of this is based upon what is out there. People don't know what's out there, and what the people are manufacturing cause folks who take it to do odd things, and it's very serious. Some people are dying out there right now for some of this. But I think you're a rational thinker when you're not inebriated with drugs. And I just wish that seems to be your problem. But then you tell me I don't have a drug problem, but you've got all these convictions for drugs. But it's one of these things that the family's going to have to help you. John, I want you to talk to me about what you might be able to figure out what plan you might be able to do to put him into a facility, which this court might consider doing before this term is completed. You know what I mean?
Yeah.
Because he needs help.
Okay.
And the family seems to be supportive of him, but you've got to be firm that his actions can't be tolerated. And it's Christmas time. It's supposed to be where the family gets together and enjoys life, and they're not with you. You're not with them, and but there's a way to avoid that. Okay. Thank you. Let her go.
And before I continue, Wolf Lore Lover, William, thank you so very much for your donation earlier. I really appreciate it. Now, on Judge Middleton, rest of the show. Go.
Now we have another Richmond case, which is set for 1:55. We're a whole half an hour behind. That is entitled Terry and Larry Richmond versus Cindy Brewster. Cindy Brewster is not here. This is a termination of tenancy because of a health hazard. Defendant was personally served. What's the status here, Ms. Richmond?
I don't know. I'll let Larry and Lydia talk. I don't think they've cleaned anything up yet.
The house is a fire trap, and I've been after them to clean it up, and they just fight us. Lydia went over there and did take a truckload of cardboard out to help, but then they won't let us back in again. That's how this all started, because they've run it from us for how many years, Terry?
26.
26 years. So we've done everything we can do to help them, but like last year, there we got turned into DHS. The kids, there was no heat, and we went over there with a furnace man, and the whole basement was full of gallon milk cartons. So this is what we're fighting with these people. We're trying to help them all we can, but they just won't help themselves.
Well, they aren't here. They have 10 days to vacate or they're subject to being evicted. This reminds me of another property you had over on Canal, or one of those where you had to
8-yard dump trailers out of there. Yeah.
Jimmy Buffett has a song called Ringling Ringling, where there's a beer can pile that's 27 years old. A lot of heartache and tears and 27 years of beers. There's a lot of heartache and tears and 26 years of accumulated trash. Let's see who this is. iPhone.
This is Michaela Gales.
Yes, it puts you guys in danger of zoning violations from the city. They were personally served. Who else is there?
Her daughter, her granddaughter, her boyfriend. It's
Swap house.
to get into to walk through the dining room. It's probably 15 foot by 12, and it's just a path. I mean, it's just a mess. And I tried to do everything I can. They're just hoarders, yeah.
Well, they have the unpleasant news that they have 10 days to vacate. That would be by December 1st. No money judgment is issued. This house is going to need an overhaul.
Yeah.
Have you been talking about Jimmy Buffett? You been to Louis' backyard?
Yes, I have.
I love that place.
Well, I like the rest. They have a great brunch, but the little deck out back, it's kind of hard to find if you don't know where it is, but I like it a lot. In fact, I like it so much, I'm going to go there in February.
There you go.
You'll probably
All
be
right.
done.
All right. That finishes our business, does it not, Terry?
Yes, it does.
Thank you, Your Honor.
All right, well, they're at an unpleasant surprise that they have a termination of tenancy coming on December 1st, but they weren't here to address it, so.
I've tried to do everything I can to work with them. They've been there forever, but it's a health hazard, what it is.
Well, as you know, you have 56 days from the day to serve the writ. So maybe something could happen, but you're going to get in trouble with the city. And I know you've got your own concerns.
The city understands. When they knew it, they go, just go address it. So they were fine. We put a new furnace in and got them up and going.
Almost like the furnace, they didn't tell us.
All right.
Yeah, the
Well, you
furnace
guys
wasn't
have-
working. They never even told us they were heating it with space heaters, if you can imagine that.
Which is a
Three-bedroom home.
fire hazard of
I know,
the first
that's
order.
That's where I'm at. Yeah. Okay, Your
All
Honor.
right,
Thank you.
thank you.
Have a good weekend.
Okay. All right, welcome back. We're going to return to the matter of Terry and Larry Richmond versus Cindy Brewster. I can see Terry Richmond, or I can see Larry Richmond. Is Terry still there?
Yeah,
She's here.
I'm here, but
All
Larry,
right, so,
Larry knows this case better than me.
all right,
Lydia
so
knows-
both
Lydia
plaintiffs
Lydia
are
knows
here.
more than I do. So
And Lydia Moreland, their property manager,
She's
is
here.
also present. Cindy Brewster is present. She's at the courthouse and they put her in the conference room. This matter was filed as a termination of tenancy as a health hazard circumstance. The plaintiffs contend that this house is in deplorable condition, health hazard, failure to obtain house and yard, failure to communicate with the landlord. Tenant has lived there for some time. Takes a while to get this much accumulation. The plaintiffs filed a notice to terminate tenancy on the defendant on September 2nd. The matter was set for last Friday,
No, Monday.
November 21st, 2 weeks ago. And the following Friday was Thanksgiving. Miss Brewster didn't show up. She had submitted a letter on November 18th from her doctor saying that she was going to be having anesthesia and he didn't want her to come to court. Well, I didn't grant an adjournment and she didn't show up. So we had a hearing on the 21st and the Richmonds indicated this is a hoarder house, which is in deplorable condition. The yard is in horrible condition. The house is in horrible condition. And they wish to get the defendant to vacate so they can take the house back and bring it into code compliance. Miss Brewster, what's your position?
I've been there 26 years. Yeah, it takes a lot to accumulate. The yard's fine now. I had somebody clean up the yard for me. And I'm working on the inside of the house. I have 3 or 4 rooms done and only 2 more to go. I've gotten rid of everything almost.
we can't get in, Your Honor.
You indicated lack of, she won't let you in to inspect the premises?
Right. And I went over there with a crew and we cleaned the yard up. We had an 8-yard dump trailer and cleaned the yard up and mowed the lawn. There were 4-foot high trees in the yard. They're growing up, there were trees growing up against the house out in the center of the yard. It was a mess.
You took an 8-yard dumpster or 8 dumpsters?
8-yard dump trailer out of the yard with
Okay.
leaves and brush and everything else. It's just craziness. And we'd send them letters. You know, we tried working with her all we could. It just.
So she didn't clean up the yard, you did, is that
Yes,
correct?
sir. Yes, sir. And Lydia hauled a pickup truck load of cardboard out of the basement. then that's definitely fire hazard.
I cleaned some of the yard, but I didn't clean all of it. Larry did most of it.
Yeah.
And I only received one or two letters about coming into the house.
Mr. Richmond, is the city on you for zoning enforcement?
Couldn't hear it.
Sorry, we couldn't hear you, Judge.
Is the city on you for zoning enforcement in this house?
They have been before, so we're just trying to be proactive. And plus it's a fire hazard. When you got, the basement's got a full of 1 gallon plastic containers. If there's a fire or something, a fireman can't even get in there, and the furnace wasn't working. The fact that Lydia hauled a pickup truckload of cardboard out of there shows that it was all starting over again with even more fire material, fire hazard material. It's just craziness. There's no reason that you have to hoard all this stuff, and it's of no value but to recycle.
The basement's all clean now.
But
All right, Miss Brewster, who else lives there? Anyone else or just you?
Now it's just me. It was my son, but he don't live there anymore now.
He was there this morning.
My son was.
So was Joe.
He came by to visit, and Joe came over to help me because I'm disabled and I'm on oxygen and I can't do a whole lot.
You know, I'm telling you.
What up? There.
All right, Miss Brewster, why didn't you come last week? Because what your doctor told you?
Because I was out of it because of the anesthesia. All I did was sleep that day.
All right, I don't want to put you guys in a position, Mr. and Mrs. Richmond, where legal aid or other counsel is going to come back and say we didn't do this right. She did send us a letter on the 18th by her doctor indicating she was going to be under anesthesia and did not recommend that she come on the 21st. I didn't grant the adjournment. I wanted to at least try to speak to her that day. But if I grant the writ now, I may have an issue. So I'm going to take a minute. I'm going to advise you of your rights, and I'm going to set this for a second hearing. You have the right to hire an attorney. If you cannot afford one, the court must give you information about legal aid, which we already did. Legal aid is not here. You have a right to have the case heard in the county or district where the property is located, which is here in St. Joseph County. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at the first appearance or make the demand in writing within 5 days of the court explaining that right to you. You can use the jury demand form and file it with the court. Pay the $50 jury demand fee and make your demand within 5 days, unless the judge waives the $50 fee for your inability to pay it. This is what's called a termination of tenancy. They finally got to the end of their rope and they want you to move out. They want to take this property and clean it probably from top to bottom and re-rent it. They gave you a notice to quit back in early September. We're now in December. They have come and done a number of cleanup matters. Not you. I don't know what the inside of the house looks like, but Mr. Richmond contends you won't let him in the house to see what it looks like. We can refer the matter for mediation. That's not likely, or the parties could seek a conditional order of dismissal, and that's not likely. Ms. Brewster, I believe they're going to get the relief that they're requesting and have you move out of this house. Have you made any provision to find another place to move to?
Your Honor.
Yes.
If she cleans the place up and she lets us come in like every quarter and walk through it without stalling and doing what she did to us this time, you know, I don't want to throw anybody out. I mean, she's been around forever, but the situation is she's getting bad counsel from somebody, and they're hoarding all this stuff that they should just be thrown out in the trash, and they're not recycling it because it just builds up, and it's a fire hazard. And I'm actually looking out for her daughter, her son, and her granddaughter. I mean, it's a fire hazard, you know.
All right, I'm going to adjourn this, and I'm going to demand or direct that you allow them to come in and do an inspection of the premises. Your testimony is you've cleaned 4 of the 7 rooms up. That's a start. I'm not sure whether I accept that or not, but we'll find out. Today is the 12th.
Tell her that
I'm gonna
Lydia
continue.
will be over there on Monday, and if she's got things straightened out, we'll continue. We'll
I'm
work.
going to continue this to December 19th,
Okay.
2025 at 11:15. The Richmonds have been your landlord for 26 years. They can agree to continue to be your landlord, but they don't want this house to burn down. They don't really want to put you out the week before Christmas. So you got another week to try to get this house cleaned up. In between now and no later than next Tuesday, you need to let them come in for Monday is when Lydia will be there.
That'll be fine. Tuesday's
There'll be
fine.
inspection of the house on Monday. We'll continue the matter until next Friday and see what the circumstance is. They could allow you to stay there.
Okay.
Thank you, Your Honor.
All right. Is anyone helping you clean it up?
I'm trying to get people to help me clean up, but it's
Well, I
hard.
think your son helped junk it up. He needs to get in there and help clean it up.
Yeah, he's the only one helping about now.
All right.
But
What's your son's name?
Corey Brewster.
Okay. Let's see what you can get done. All right, we'll address this next Friday at 11:15 a.m.
Okay,
Thank you, Ms. Brewster.
thank you.
Thanks, Your Honor.
Mr. Rich, thank you.
Okay.
All right. That's why less and less independent people are serving as small town landlords. Whole thing's getting corporatized. All right. We'll address that next week. It's been a long morning, a long afternoon, and a long week. Today's first line was called Steal My Kisses by Ben Harper. We'll be back Monday morning with another full day. Everybody, hope your temperature rises some, and we'll see you on Monday. Hope I feel better by then. All right, now we're to Terry and Larry Richmond versus Cindy Brewster. Cindy Brewster is here. We've had a lot of hearings on this matter. Ms. Brewster, can you hear me?
Yes, I can.
All right, the Richmonds are here. Ms. Moreland, their property manager, is also present, and Larry Richmond is here. All right, we started this on November 21st. It was a termination of tenancy case. The house was in very poor condition, hoarder circumstance. The defendant did not appear at the first hearing, and I set a second hearing for December 5th. Excuse me. I think it was December 5th. Terry and Larry Richmond were there. Miss Brewster was there. She's been there for 26 years. She contended that she cleaned up the house. Mr. Richmond said it wasn't her. We cleaned up the yard. And they were willing to allow her to stay there if she would begin to clean the property up. So we continued the matter until today, December 19th. Mr. Larry Richmond is here on behalf of the interests in this property. Mr. Richmond, what's the circumstance here today?
I'm gonna let Lydia, she's had more contact with her, Your Honor.
All right. In fact, everybody, all three of you, please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Oh, I see Terry's hand there also. I didn't
You
realize
said
she was
everybody.
also- Well, I didn't know you were there. Hiding out. All right. And your name is Lydia Moreland, and you're their property manager assistant for the Richmond's properties.
Yes.
And we learned from previously, you've actually been to this property and actually carried stuff out yourself.
Mhm.
What's the current status?
So I did a walkthrough. Cindy was not home when I did the walkthrough. She had another gentleman there. They were making strides in the right direction. I told him that. I spoke and said Larry would want to walk through too. And I asked him if it was her intention to stay living there. And he said he thought so, but he wasn't quite sure. And so I said she needed to get in contact with us. She got in contact with us. Larry went to do a walkthrough. She asked that he come after 2:00. He went at around 2:30 and somebody was there when he pulled up, and then they shut the door and locked it and wouldn't let him in. So
I wasn't there, so I'm not sure on that.
she said she wasn't there, so she's not
Well,
sure.
she was supposed to be there.
She
Well,
yeah.
Said she'd be there, so she should have called.
I didn't know I was supposed to be there.
Well, you said you'd be there, Cindy, and somebody, why would they lock the door when they know what's going on? It's been going on for 3 months.
I know I told them not to be locking the door.
They saw him pull up, and he went to go and knock on the door, and they had locked it and wouldn't answer.
The front door was wide open. When I pulled up, they shut it and locked it, so.
I'm sorry about that.
Well, it's craziness what's going on. We've tried to help and help, and it's time for you to just move. It's just crazy.
I've gotten almost all the rooms are cleaned up.
I know you've said that time and time
But we
again,
can't,
Cindy.
when we try to speak with you directly, we're unable to.
And you won't
Nobody's
return
on my
phone calls.
We've
all right, this is a month-to-month tenancy. The defendant has filed this action both as a regular notice to quit. The first notice to quit was filed in September. The defendant has remained in possession of the premises. The plaintiff has gone to considerable expense to clean up the yard. The landlords are under I'm not sure what the word I want, under pressure from the city of Three Rivers because of the zoning non-compliance for all the junk in the yard. So they cleaned that up. She has been a tenant for 26 years. They wanted to work with her. They've deferred this a couple of times, and she ended up giving them the big middle finger by whoever was living there, locking the door in his face. So, Miss Brewster, they don't want to deal with you anymore. They want you to move, and they're going to come in with a crew and clean this mess up.
I tried.
So whoever's living with you didn't do you any favors.
Your Honor, I tried to find another place to rent, but the Edgewater Apartments in Three Rivers, but they told me that Larry gave me a bad rental review.
we gave an honest review. We have to.
I paid my rent every month.
But it wasn't about whether you paid, it was about your house. They asked about your housekeeping. And we had to be honest.
Yeah, you're not going to be an ideal tenant when they find out you were a hoarder at the last place. I was hopeful this matter would be resolved, but they were working in one direction, you were working in another. You got 10 days to move or you're subject to being evicted. December 29th.
I have a disability and it's hard for me to get that stuff finished, cleaned up. And on top of that, I got to have foot surgery in January. I was
All right.
have to get some more time.
She has her two adult children living with her and her boyfriend. There's three other
Yes,
adults
that's
in that place.
part of the problem. There's a bunch of people in there. They've reached the end of their rope, Miss Brewster. They're entitled to the relief they're asking for. If you don't move your stuff out, the sheriff will come move it out. It probably won't be till after the first of the year. You get your sons and your boyfriend to help get your stuff out of there. This applies to everybody who's in there.
It's only I'm the only one that lives there.
All right, well, maybe they can give you some help. But whoever was there and slammed the door in his face didn't do you any favors. If you go out to the counter, we'll give you a copy of this. You do also have 10 days to appeal this. Meg Bauer is here from Legal Aid if you'd like to consult with her, but she's about to be real busy with me in another case. And,
Judge, I'm always happy to consult with folks, but she would, it would be, obviously, she'd have to wait for me to be available.
Ms. Brewster, if you wish to wait, go out to the counter and get the order. And then, if you wish to wait, you can come back. But, they're entitled to the relief they're asking for. They want you to move out. And they've been asking you since August or September to do it. And then they tried to work with you and it just didn't work out. So you can go out to the counter. Do you wish to talk to the lawyer from legal aid?
Yes.
All right, then you come back to the waiting room when you're done. All right.
Thank you, Your Honor.
Thank you. All right, I've blocked out an hour for this next case, which is Centerville Mobile Home Park versus Spiech. Miss Spiech is here and Miss DeCenzo is there. All right, we spent a lot of time on this and
Judge, this is the first hearing, I think, actually.
Is it?
Yes, I was out of town for the first
it was
hearing.
adjourned. Yeah, we had, this is a matter of money. Have you guys spoken?
I did not receive any communication from plaintiff's counsel. I was unaware which attorney from the law firm would be appearing. But like I said, I have not received any communication from plaintiff's counsel.
All right. Miss Spiech, come up and have a seat. Spiech. All right. Now this is. All right, let me call the matter. Centerville Mobile Home Park versus Spiech. Donna, she is present here with me at the court. Meg Bauer has filed an appearance on her behalf, and the counsel is here on behalf of the plaintiff from the Levine Swistak law firm. And we'll have you place your appearance on the record here. You're logged in as 30-day termination.
Yes, and I've been trying
desperately
to change that, Your Honor, without success. Daniel Landman, P35797, appearing on behalf of the plaintiff.
I'll change it. I want to address a little something before we begin. Your manager or owner, Ms. DeCenzo, is in the waiting room. I'll bring her in a minute. When she was here last time, I got an email from a viewer in November about how disrespectful and distracting she was at one of the previous hearings. And that particular person was outraged that she was smirking and laughing during the proceeding. And I thought I had forwarded that on to you, but I'm not sure that that was done. So anyway, we'll bring her in and hopefully it isn't be an issue or I can turn her camera off. But encourage me to play back the video. She's laughing and drinking water and making motions to other people. And that viewer felt she was very disrespectful. We'll see. I often don't have time to see what's going on on the screen. All right. This is file number 252403LT, Centerville Mobile Home Park versus Donna Spiech. It was a demand for non-payment of rent. Meg Bauer filed an appearance on behalf of the, what do you need?
Is Meg able to speak quickly?
She said she was going to have to wait.
Okay.
So I told her to just stay in the room, and then when Meg is, this may take us a while, but I told her. All right.
All right, thank you.
We adjourned it. We've had several other cases with this park, and there are hidden costs that end up in the amount pled for that aren't often apparent. Miss Bauer had applied for an ex parte escrow order, I believe was granted. Her claim is that the calculation for the amount due is not accurate. So let's start at the beginning. Mr. Landsman, what's the claim to rearage at this point?
Your Honor, for purposes of this hearing, my client is claiming the following. Lot rent of $1,320, which is $440 a month for October, November, and December. Late charges of $120 total based on this court's policy of capping late fees at $40 a month. A meter fee in the total amount of $25.50. That's $8.50 a month for 3 months. Total water and sewer of $155.26 for the 3 months. That's $51.17 December, $53.33 November, $50.76 October. An administrative fee of $15 being $5 a month. Mobile home tax of $9 being $3 a month. And a line maintenance fee of $15.
No, just slow down.
Sorry. Say when.
Mobile home tax, $9, 3 times 3. And what was the next?
And a line maintenance fee of $15, which is $5 a month for 3 months. That results in a grand total of $1,659.76. And court costs are $170.05 for a total of $1,829.81.
All right.
And I'm gonna add something else, Your Honor, just unrelated to the dollars. I was very surprised to receive an ex parte motion to adjourn from counsel. Counsel was well aware that our office was involved in the case when she filed her appearance. I did not receive, and it is possible counsel reached out to Jarrett Levine, but I did not receive a request from counsel to stipulate to the adjournment. I think, as I understand motion practice, when there is an attorney on the other side, I believe it is inappropriate to make ex parte motions. I think the proper procedure, in my mind, should have been to reach out to our office first to see if we would have stipulated, and quite frankly, we would have as a courtesy. And then if in the absence of receiving the courtesy, then filing the motion and perhaps requesting a hearing before Your Honor. Certainly, Ms. Bauer being out of town was an appropriate excuse for an adjournment. We've I think adjourned cases from her office before by stipulation, and I was surprised that it was done on an ex parte basis, and to a degree even more surprised that the court considered it when the court was aware that there was counsel on the other side. If my understanding of the rules is incorrect, I will happily stand corrected.
No, I think your court rule is correct. There was an escrow in there. But Ms. Bauer, how do you address that? He is taken aback by your ex parte request to adjourn this and my willingness to grant it. I would not have granted it had there not been an escrow order in there, but what's your response?
Thank you, Your Honor. The adjournment request was less important than the escrow order. We were asking for that escrow order because my client has been unable to pay her rent, and because the whole basis for this case originates out of plaintiff's unwillingness to accept anything less than $175 per month in late fees. In order to give my client a place to pay her rent so that she didn't lose it, we needed an escrow order so that it could be secured and so she could demonstrate her good faith. I have been in communication with plaintiff's firm about a previous case at this park, the Kloppenstein case, with no response in an attempt they were refusing his redemption. I sent letters to Mr. Levine's office. And so in light of the fact that I needed an appearance in order to get the escrow order, but was going to be out of town, I had to also ask for the adjournment. Well, that said, this issue has been a repeated issue clogging your docket and being inappropriately addressed by this park, I think. And so we needed to get this in front of you so that we can get this resolved. Now, Mr. Landman has said today, for purposes of this hearing, we're going to charge $120, but that doesn't stop the fact that they are continuing to charge the tenants.
All right, when you're getting an argument, the proper procedure would have been asked to adjourn it. You asked for the emergency. Certainly, they wouldn't object to an escrow order, I would think, but both you and me didn't clearly strictly follow the rule here. For that, I apologize, Mr. Landsman. I'm sure you would have agreed to the adjournment. At any rate,
Your Honor, if I may,
was,
at one point in time, I was known in Ms. Bauer's office as quote unquote the nice one from Swistak and Levine. That was due in no small part to the fact that my cousin used to work as a legal assistant in that office. So certainly I would like to think that I have dealt at all times, although adversarially, with individuals in that office respectfully.
all right, well, let's try to parse this out. The defendant's contention, both in the previous case and this case, is that the plaintiff wouldn't accept payment without their, and nobody allows $175 a month late fee, probably anywhere. And I think this is lot rent. There's a bunch of extra stuff in here, which isn't in the lease, which are little things. The $850 times 3, the sewer is certainly this administrative fee of $5 a month, mobile home tax, line fee. I don't know if those things are in the lease or not, but those may also be issues, but it's in the billing. It shows mobile home tax, administrative fee, meter fee, lot rent, so they were aware of it. But so let's talk about what we're at right now, Ms. Bauer and Ms. Spiech. Lot rent $440 per month, October, November, December. Are we in agreement with that?
Yes.
All right. Late fees, 3 months at $40 per month. Now, defendant may claim she's not late because she's tried to pay October or at least November and December, and the plaintiff wouldn't accept it. What's your response to the late fees, Ms. Bauer?
Ms. Spiech voluntarily or sua sponte attempted to pay a $50 late fee on October 17th on top of the balance that they claimed she owed, and that payment too was rejected as below minimum. So we object to anything in excess of $50 in late fees. I do also want to put in here, we object to court costs because because she attempted to pay the entire balance through October plus a $50 late fee of her own that was prior to receiving advice from counsel on October 17th. And then subsequent to that, she attempted to pay all of the assessed charges, $440 in lot rent, the meter fee, admin fee, the tax, line maintenance fee. She attempted to pay all of that, plus the prior month, plus the $50 late fee on November 4th. which would not under the lease trigger any late fee provisions. So the only late fee that the defendant would consent to in order to seek resolution perhaps would be a late fee for October.
I can't tell from what I'm looking at how much I have in escrow. Maybe I can look in the electronic file. Can you tell me how many escrow payments you've made, Ms. Spiech?
2.
So I have 886.
Judge,
I paid
you have
1,068 at first, and then I just paid December's before it was late, which was $514. So you have like 1,500 and something in escrow.
Judge,
3 months.
1,068 was paid on November 21st, within a day or two of when the escrow order was entered, and then $512 on December 5th, according to the receipts I have, for a total of $1,580.
All right. Where does that bring us?
That brings me.
All right, we'll see.
Looks
Mr.
like it's a
Lansford?
difference of $79.76, Your Honor.
And that would be the $240 late fees that we dispute. And of course, Ms. Spiech would have no notice of this sort of random imposition or decision on the number for the late fee, so she would have no way to account for that. But again, she wasn't late. As soon as the escrow, she attempted to pay on November 4th. It was rejected by their lease pay system. So we asked for the escrow.
Just a minute. Mr.
Yes,
Senzo, would you unmute your mic?
Hi, Your
I'm
Honor.
gonna blank your camera out. Viewers have contacted the court regarding your behavior on the screen. You're very animated about agreeing or disagreeing with what's going on. They felt you were very disrespectful to the court at the last hearing and were shocked that I didn't do anything about it. I wasn't paying attention, but you're doing that now. You're very animated with your approval or disapproval of what is being said. So I'm going to shut off your camera, but you'll be able to see us.
Understood.
And Your Honor, I will also jump in at this point and indicate to whichever viewer or viewers felt that shaking one's head is disrespectful, I am happy to take it up with those viewers directly, and they may feel free to contact my office, because I am completely and utterly opposed to their position.
Well, Judge, I would like to take a point to say that I have actually had repeated concerns about the respect that this park has treated to my clients during these hearings. And for example, when Ms. DeCenzo's colleague shared his screen with my client's personal information on the YouTube feed without your consent and over my objection, it is not just the viewers that have been concerned. But I'm not here to make ad hominem attacks. I'm just here to get this resolved.
Yes. There we go. All right. She can hear us, but she can make all the gestures she wants and nobody can see it. All right. So we're getting close to where we need to be. So, Mr. Landsman, what's your response?
Your Honor, the tenant, firstly, I disagree with the court that, quote unquote, no judge would allow $175 in late fees. I could list several judges across this state that have allowed that or more. If this court chooses to, have its own cap, there are other courts that have done so.
The law on late fees isn't even clear. Some judges allow no late fees.
That's true. And some others have caps based on whatever their reasoning is, and others allow late fees.
But I didn't know anybody was allowing one that big. But maybe so. You practice all over. I'm just here in Little Centerville. But yeah, the law on late fees, in fact, if you read it carefully, it doesn't even seem to allow it at all. But I've always allowed it, and I've let the number go up. But at any rate, fair enough.
And what I will say is, that this tenant agreed to late fees of $175 in the lease. The lease is a contract. The words of a contract are to be given their clear meaning pursuant to Rory versus Continental Insurance, which is the landmark Michigan Supreme Court case in that area. As far as my client's rejection of the payment that was not a payment in full, if it had accepted that payment pursuant to Park Forest of Blackman versus Smith, Court of Appeals decision from, I believe, 1983, my client would arguably have been prevented from filing this case. So therefore, it was justified, in my opinion, based on the prevailing case law, as I understand it, from it was entitled to reject the lesser payment. With that in mind, obviously, this court is entitled to make whatever ruling it
Let me
wishes
stop
in
you
terms
before
of
you
what
go
may be
forward.
owed.
This isn't a termination of tenancy case. It's a non-payment of rent case.
That's right.
And Park Forest doesn't apply to non-payment of rent cases. It applies to termination of tenancy cases. So if you file a termination of tenancy, you're right. You're not supposed to accept any payment after that. If it's filed as a demand for non-payment of rent, the defendant is entitled to tender rent and the plaintiff's supposed to accept it. But
I appreciate, Your Honor, this court's interpretation. Again, we practice all over the state and other judges have taken a different position. So therefore, we advise our
they've
clients to
taken
err
a
on the side of
position that
caution.
Park Forest applies to non-payment of rent cases?
There have been rulings to that effect. We have not, we don't like them, but there have been rulings to that effect.
All right, well, so what does that do for a tenant? Some judge in Sanilac ruled you can't make a payment on a non-payment of rent case. So here in Centerville, the landlord decides he's not going to accept any rent. I've never even seen that before, and I just picked Sanilac out of the air. I'm not accusing the judge that may be there, but at any rate, we need to get to where we need to get to. So, all right, enough of me venting. Go ahead. I cut you off.
Oh, no, I was just going to say that obviously we have to keep track as best we can of which judges are interpreting things which ways. And certainly I will note, and my office will note, that in your opinion, Park Forest doesn't apply in non-payment of rent cases, and we appreciate that input, and we will work accordingly with that.
I think I may have mentioned this before. We had a session a number of years ago when I first came to the bench on landlord-tenant law. And Craig Alston was the judge. He was the acknowledged landlord-tenant guru in the state of Michigan for district judges. There were more than 200 judges there, maybe more than 150 district judges. And he put these scenarios on the screen and we would discuss these scenarios and you get 8 different answers to the same question. And I remember thinking, isn't the law supposed to be more clear than this? And so I made a decision at that point, at least I'll do it the same way every time so the lawyers will know what to expect. As you know, right now, there's a big dispute as to whether you can do a non-payment of rent case in a lot-only mobile home case. Some judges have ruled that you cannot do it, and other judges like me allow it because it can benefit the defendant. So all I can say is I try to do it the same way every time so lawyers know what to expect, even though there may be some differences in how other courts do it. I think I'd mentioned a judge wrote a very learned opinion on why she does not allow it in her county. And I've read several briefs from law firms, I think including yours, on why it should be allowed, but we need more guidance. So we're not terribly far apart.
Judge, may I address some of the points my colleague?
Well, I didn't let him finish what he was saying. Yeah, I keep cutting him off. So I'll let him finish and then I'll let you respond.
Thank you.
And I appreciate the court's consistency, and I think certainly when I've appeared before you, Your Honor, on these types of cases, you have been consistent. So as such, when we were scheduled for this morning, thus the reduction in the late fees to $40 a month in conformance with this court's policy. I'll yield the floor to Ms. Bauer.
All right, Ms. Bauer.
Thank you, Judge. To address the Park Forest issue, it is inconsequential in this matter. Plaintiff's complaint is dated October 20th. However, Ms. Spiech attempted to tender the entire balance due plus the late fees, a total of $563 on October 17th, 3 days prior to the filing of this complaint. So Park Forest, even under Mr. Landman's interpretation, wouldn't apply until a case had started, but she had attempted to make her payments prior to this case starting. So regardless of the interpretation, that issue doesn't hold water. She attempted to pay them everything she owed. They still rejected it because she did not attempt to pay them $175 late fee. So let me turn to that issue.
All right, well, let me stop you right there. Mr. Landsman argues she signed a contract that said she agreed to pay $175 a month.
That's exactly
and
what I was
me
going
or
to.
you or somebody else said, well, hey, now granted, they should have accepted whatever she tendered, but the lease says that the late fee is $175 a month.
Judge, that was my next sentence. I said, so on that, to that point, a contract clause for late fees is a liquidated damages clause. It is supposed to be a reasonable estimate of the actual damages that are otherwise hard to calculate. That the breaching party occurs as a result of the non-breaching party occurs as a result of the breach, right? That's liquidated damages sort of 101. However, a liquidated damages clause is unenforceable if that clause is a penalty. If it is not intended to recover or account for actual and estimable damages actually incurred. So we have two issues here. I'll say the defense's position is that, sure, that clause for $175 is in the contract, but it is a penalty and therefore it is an invalid liquidated damages clause and the court should not enforce it. I can provide a couple of citations, although Ramada Development Company versus United States Fidelity. And
well, and I'm not proposing to enforce it. So they, even under your client's position that they should have accepted her payment, it was not payment in full. If she unilaterally decides I don't have to pay the late fee, I hadn't made a ruling on the subject, the plaintiff still would have had a right to file this action, which they did, because there would have been at least some arrearage at that point, so I would be inclined to allow the court costs.
The judge, by that argument, my client has to pay in order to defend herself.
Ms. DeCenzo has got her hand up. Ms. DeCenzo, you had a question?
Hi, Your Honor. Yes. I just want to apologize. I am a very animated person. And I promise you, it's not a sign of disrespect. More of a just upset that we're even here. We don't want to be here, and we respect your time. And we did not want to come to court today. So, in compliance with the last two rulings that you have given in this courtroom, we actually did change our late fees, whatever the term you want to call them, in efforts of trying to do right by you and your judgment. On the 20th of November, we actually sent a notice to our tenants letting them know that we were going to be actually obliging with your $40 late fee recommendations. And we sent a notice to Donna on the 20th of November, literally stating that we want to remain in compliance with your recommendations and that we were dropping the late fees to $40 for all tenants. And she still chose not to pay in December.
All right, thank you.
I'll
All
state
right.
that at that point, the escrow order was already in place, and I do believe that had we not filed this motion in order request for ex parte order, this change would not have happened. We are glad to hear of this change. But I don't believe it would have happened had we not had to file, or had we not filed.
May I speak?
Yeah, I let her speak.
On November 4th,
Now you have to speak up.
on November 4th, I did try to make my payment for November and October's with $50 late fee instead of a $40 late fee, and they locked me out. For 6 weeks, I tried to make my payment.
Yeah, that's your attorney's already represented that.
So I just wanted to respond because she's saying November 20th. Well, how come you didn't let me pay it on November 4th then? And after that, it was done. The escrow order was in.
All right, we are very far apart.
So I let my lawyer do the rest, and they kept harassing
fair
me.
enough.
So.
All right, so plaintiff's claim right now is for $1,659.76. And that's through December with a $40 late fee and the other related fees. Defendant has paid to this point into escrow $1,580, which is, as Mr. Landsman said, $79.76 apart. And as Ms. DeCenzo says, she didn't want to be here. I think it's unanimous. None of us wanted to be here, but here we are fighting about $79.76. But as Ms. Bauer said, these challenges have led the park to changing some policies and procedures, and they're new owners and they're learning our procedures. So maybe there's some benefit from this. The other issue is the filing fee of $170.05 that defendant objects to. And I didn't make a ruling, but I indicated my inclination is to allow the court costs. So that would be $79.76 minus $170.05. $249.81 would be the total through December. All right, Ms. Bauer, do you wish to again make your argument as to why there should not be any court costs?
I do. I'm looking for the citation right now. There is a portion of the Summary Proceedings Act that suggests that the court should take into account whether or not to award the fees based on whether there is any mitigation in the amount demanded. I believe it is 600.5741. In determining the amount, yeah, it is that section. And had
600.5701.
5741. In determining the amount due under a tenancy, the jury or judge shall deduct any portion of the rent which the jury judge finds to be excused by the breach. The statement in the judgment shall be the judgment. All right, I'm sorry, Judge, that is not the right citation. This being a first hearing, I didn't realize we were going to be litigating it this far today.
Yeah, there is that. This is just the first hearing. I was hopeful we could get to the finish line today.
If the plaintiff fails to prosecute his complaint, or if upon trial or motion the plaintiff is found not entitled to possession of the premises, judgment shall be rendered for the defendant for his costs, which shall be taxed and collected in the same manner as other civil judgments. So MCL 600-57.47. The only thing litigated here, the only damages the plaintiff was seeking is those $175. Had we not filed this motion, had we not asked the court for an injunctive order preventing the park from assessing these fees in the future, this change wouldn't have happened. So to award the plaintiff its costs is to reward them for filing these actions and to penalize Miss Spiech for defending her case. And we have not asked for my costs and fees in this case, although we could.
Your Honor, the motion for the ex parte escrow order requesting injunctive relief, I think, was horribly overbroad. An escrow order can be entered without an injunction. This court never granted the injunctive relief requested by Ms. Bauer, and it would have been wholly inappropriate to do so without holding a hearing with notice and an opportunity for response from all parties. She could have requested perhaps a temporary restraining order with later an injunctive hearing. She did not attach an affidavit or any other item that would have persuaded this court that her client was suffering irreparable harm. So I think to argue at this time that this court granted injunctive relief, quite frankly, probably the appropriate remedy would have been filing a separate lawsuit in perhaps circuit court and asking for equitable relief. But I think to argue today that somehow this court granted her an injunction and therefore she is the prevailing party, I think is wholly misplaced and flat out wrong.
Judge, that's not what I'm arguing.
I thought all I granted was the escrow.
That's correct. That is all you granted. And I'm not arguing that we prevailed on that. Also, plaintiff didn't file a response to my motion, which they were.
It was an ex parte motion, Your Honor. It wasn't scheduled for hearing.
No, that doesn't. The motion rules for filing a response. The timings still apply. The point is, we're not that we prevailed on that request. The point is that we prevailed on getting the late fees mitigated. Potentially, you haven't made a ruling yet.
Well, you did just now. I didn't even make a ruling. They just capitulated and agreed to move it to $40. I didn't make a court order or a court ruling. They just agreed to it. My opinion is they're entitled to their costs. We're going to set a second hearing, and you guys can think about it in the meantime, which would mean through December, the defendant would owe $1,659.76, offset by $1,580 that's presently in escrow, leaving a shortfall of $79.76.
Judge, you're intending to award them late fees for November and December, despite my clients paying within days of the escrow order and paying on the escrow order on December 5th?
Because it's not late until after the 5th. And I was not late for November.
Yeah, that's a legitimate point. I don't want to fight about this anymore. I'm going to kick this can down the road. I resent spending an hour and a half to fight about $80, but we'll have to try to be accurate. Even it is a small amount. You're trying to make your point.
Attorney Landon could have called me also. This is the first I'm hearing of the concession.
The first I'm hearing of it as well.
Oh my goodness.
All right. December 29th is quite full, but in for a penny, in for a pound.
I'm going to start using that at our case review decisions, Judge.
Yes, well, that's the first day back after the holiday and it's already crammed full of stuff. We're going to continue this. And again, every time we continue it, it's an additional cost to the plaintiff. Defendant doesn't pay cost for her services. Ms. Bauer argued that perhaps there should be an assessment of their costs. But maybe the parties can just agree. It'd be can agree to settle on a figure, in which case neither party would need to appear. But I'm going to continue this to
Judge,
12, 29, 25 at 2:45. Yes?
Although we are a nonprofit law firm, we do still incur costs, and we are authorized by statute and by our regulations to request costs and fees. We just simply don't do that very often because it tends to harm our clients more than help.
Yes.
Your Honor, they're only entitled to
I'm not insinuating
costs.
you didn't incur any costs, but your client didn't. Now, she's well represented here, and you're fortunate to have competent representation.
Yeah, I'm very lucky. And I really appreciate
As I indicated, they're new to this park. They're new to this business. They're well represented. Also, Jared Levine practices landlord tenant law all over the state. That law firm does. Mr. Landsman's been around, and he's done a good job for his clients in the past. And sometimes we need to fight it out a little bit to get to a place where everybody knows where to go moving forward. So I think we're getting there, but we're fighting about not very much money. I would like to resolve this in December because I don't want to do another escrow payment in January.
Thank you.
I'd like you to just pay your rent to your landlord, but we're not very far apart. Ms. Bauer contends, perhaps with merit, there should not be a late fee for November or December because she attempted to tender the rent and the plaintiff wouldn't accept it. So in essence, we're fighting about $80. Well, we're actually fighting about 24 cents.
$140.
If I took the two late fees out, the arrearage would be a 4-cent credit. I would allow the attorney fees and the costs. So if I grant $80, you'd have a 4-cent credit toward January's rent, and I would allow the court costs of $170.05. So that's where we are. Not 4-cent, a 24-cent credit. All right. I don't know if you guys are in a position where you wish to speak to each other at some point further, but I'd encourage that. We'll come up with some sort of a ruling on December 29th. All right. Thank you all. Mr. Senzo, thank you for your input as well.
Thank you, Your Honor, and I will wish the happiest of holidays to the court and its staff, to Sister Counsel, and to her client.
All right. Thank you all.
Thank you, Judge. Ms. Spiech will be in touch.
All right. Miss Brewster is still in the waiting room, Meg.
All righty.
Miss Spiech, you're good to go.
Thank you, Your Honor.
Well, she was in the waiting room. Elaine, did Miss Brewster get tired of waiting?
Sorry, I got busy.
Did she leave?
She did, but she left her phone number for Meg.
All right. I'll close the live feed.
Everything was flowing right along. Fixing housing 401k plan versus Erica Ward, Aaron Ward, and all other items.
Good afternoon, Your Honor. Steve Etherly on behalf of Plaintiff Fixing Housing 401k Plan.
Donna TOPE on behalf of Erica Ward and Aaron Ward tenants.
Your Honor, I believe my client Griffin Hawk is. I think I see him right now. He's on Zoom. He couldn't attend today.
All right. Yes. What is your name, sir?
Me, Griffin Hawk.
Yes, sir. Say again.
Griffin Hawk.
Yeah. Okay. All right.
Your Honor, we're here for our fourth pretrial hearing. If you recall from the last hearing, you adjourned to give plaintiffs time to seek alternative counsel.
Right.
It appears that they used that time to file a dispositive motion and an omnibus motion for repairs and Ms. TOPE's motion for withdrawal 2 days before this hearing, which I received a copy at close of business on Wednesday, which forced landlord to file its own MSD, which was filed with the court this morning. So it appears it is further delay by tenants, and it's another month with my client not receiving any rent payment for his property.
So I can just tell you what I agree with everything that you said. I can just say from the court's perspective, because of the way that my docket is, I did not see these various motions actually until late yesterday, but I have a life. So it was really this morning that I saw that. And then I saw your motion came in.
Yes.
And I have that.
Your Honor, I do also, I brought a hard copy if you needed one.
Of your motion?
Yes, landlord's MSD. You got it? Okay.
I got it.
Good.
Okay. So, Ms. Joe.
Yes. I filed judge's copies for you that had the tabs attached for the 3 motions for repairs, one of which is an emergency. And that's why things were delayed in getting the motions to you. I also filed a motion for my withdrawal, and I gave the underlying theory that the tenants have agreed with, and that is ready for your signing. I attached an order at the back of that. And then I filed, and it's effective midnight today because we had the emergency request for repairs that was made a week ago. And we filed a motion for dismissal with prejudice and damages based on retaliatory eviction.
See anything wrong with all of that?
Your Honor, I know you have expressed several times your not order and not opinion, but your advice that my representation of the wards somehow is ethically compromised. But I have tried each time that I have appeared before you and you have expressed your concerns, I have tried to give you the underlying basis for why I represent them and how I have conducted myself in that representation, including today. And that is in my motion, the underlying legal basis, and it's on Exhibit 1 at page 5, and it says that a bank account or other account held by a third party generally established in the name of the tenant into which whole or partial rent deposits are made to show that the tenant was ready, willing, and able to pay the rent, but is withholding the rent until a certain problem is fixed. And that is exactly what Erica Ward did. The money was not held in a legal IOLTA account.
Which might be part of the problem.
And you say might.
You can't do both.
Okay.
Counsel.
Okay. I agree. My clients and the plaintiff do not need to spend any more time with your concern with how the money was held. I have filed a withdrawal. They have agreed. They are perfectly able, competent, and know everything about this case and are wanting to exert their right to represent themselves. And that's what this motion says. So they signed it. It's a stipulation, and I've signed it, and I have the order ready for you.
So are they really? So if that's the case, then why is this effective at midnight?
Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica, made to them to fix electrical fixtures in the residence that are used for auxiliary heating, which in this temperature weather is essential for the safety of the residents, and the outdoor security lights, which have gone out, and with the unsafe conditions out in the driveway and the walkways, those are essential. And the plaintiff refused to reply, refused to make the repairs. And so that, knowing that we had this hearing today, that is one of the motions, motion number 3, which is requesting permission for the defendants to make essential minor or electrical repair, which the plaintiff has refused to address, and to deduct the cost from the rent on January 1st.
You can't have it both ways.
How
You can't have it both ways.
Then I would ask that you recognize that the wards made that request of the plaintiff. Take me out of the picture, and they did not reply. And if you would like them to stand up here and say exactly what we say.
Are they going to be able, folks, are you going to be able to give me the legal arguments that are necessary?
Legal arguments? I
Yeah.
have to state the facts.
Okay, but you understand that I would be taking facts as I found them, applying a legal standard to that and making a decision. You understand that? And are you prepared to make the legal arguments?
I guess I don't understand that.
I understand your question. I think we're in tough.
So what's the answer?
Yes, we are. We'll do the best we can. You know, we have a business that doesn't make any money. The attorney fees would be.
Sir, I get it, but I also can't.
It's a tough situation. I
Pardon?
understand your question. So yes, we'll do the best we can. And it is what it is.
Let me ask this, the conditions that are complained of, how long have those existed?
So.
The electrical outlets.
Oh, the electrical outlets on the outside I've only noticed as of this winter. They were working fine.
So how does this become an emergency motion?
Because the water freezes and then.
No, I get that happens in cold weather. I understand
I
that.
have to use water heaters.
Okay, but I guess maybe I'll ask this. You're asking me to address this as an emergency motion where the court has only had an adequate opportunity to view it. Plaintiff has only had as short time, if any, to look at it. And I have to first determine that it's an emergency. And I'm having an issue with that. If you'd known the conditions existed, this motion shouldn't have been filed on Wednesday.
The reply was made. The request to repair the electrical was made When? A week ago?
Yeah,
But that's not the issue.
I didn't realize it wasn't working. I got to play with it.
Okay. The weather makes it an emergency. The receptacles that just were noticed that aren't working are used for auxiliary heat in the residence. The security lights just stopped working. The plaintiff was requested to make the repairs and respond, and they did not.
Folks, are you going to be able to handle this from a legal standpoint?
I will.
You realize, so hang on a second. You realize that plaintiff has filed a motion for summary disposition. It's going to need to be answered and then argued before this court. Have either of you ever argued a motion for or a motion for summary disposition?
Yeah.
How are you intending on doing that then?
I just saw it on the way here, so I didn't even review it yet.
It's the last one.
Oh, I know where it is.
Okay. I'm not worried. I was trying to be helpful.
Let me just tell you, I will hear all of these motions at some point. There's not a doubt I'll do that. But I don't and can't justify that motion is an emergency motion that
your call.
Plaintiff hasn't had an opportunity to view and respond to. But then you're requesting that I take some action as against plaintiff. And I don't deem this to be an emergency. I think I won't go as far as plaintiff counsel that it's a delay, but it's just, it can't be an emergency at this point. Because this condition, to the extent it does, must have existed. And it didn't just get cold Tuesday.
No, it didn't. But the need for auxiliary heat became apparent with this frigid weather.
Because of the water. Because of the freezing of the water.
No. Because the electrical outlet in the residence became known to be faulty a week and a half ago.
I don't have any way to check that.
I know.
Any way to.
Well, I did include
not having them respond to that. Counsel, at best, when you have motions such as this, even though these are summary proceedings, you have to give them the time under the court rule.
We requested the repair a week and a half ago, and I included those emails and their non-response in the motion. And if you can't act on it now, I totally understand your ruling because it wasn't timely, but it was as timely as it could be given the fact that we gave them 4 days to reply to making the repair themselves or telling the tenant to make the repair, and we got no reply. So that's why the motion was filed on Wednesday.
I don't care.
Okay.
File the motion whenever you want. I just don't see a basis to hear. I don't see a reason to hear it on an emergency basis.
Got it. We had this hearing already scheduled. So I thought it would be in judicial efficiency to present it to you now rather than.
There is nothing about this that is leading to judicial efficiency.
Well, that is a motive. That is one of my motives. It's judicial efficiency. I know you don't agree, but.
Well, no, I just don't need your help. Because I can do that on my own. counsel.
She filed a dispositive motion 2 days before. And is now claiming that it's an emergency. Your Honor, I would add that if you're going to when you're addressing the pending motions, to rule on our motion first because it moots out their motions. And also when they're talking about emergency, my client is also being prejudiced because he's not getting any money from the property and he's defaulting on his own financial obligations. Mr. Hawk can provide more information on that, but he's suffering his prejudice while they're delaying for months. I mean, Your Honor, we're going on almost half a year where they're not paying rent. So, Your Honor, I would respectfully ask you to rule on our motion.
And let's just be clear in terms of the not paying the rent. I permitted plaintiff to keep a certain portion that he had been paid to him, whether rightfully or wrongfully it was deducted, but I permitted him to keep that. And I have in escrow the ordered amount of the $41.25, which I ordered in November, and December's $5,500 has been placed in escrow. Yes.
I should have been more clear. Receipt of money, Your Honor. I would.
No, I know what you meant, but I just wanted the record to be clear.
Yes.
As to.
I would like to make a point though on the partial payment. My client's Chase bank account, because there was no activity with them not paying rent, it was, I think, deactivated, so he can't even cash this check. They're saying that he cashed the check. He can't cash that check.
Well, it was withdrawn. The check was cashed and the money was withdrawn. Finally, like 3 days ago.
Why don't we have him? Why don't we have? Yeah, go ahead, sir.
Can I comment?
Yeah, go ahead.
Okay, thank you. Sorry. So because of the non-payment of rent, we've experienced loan defaults, which was intentional. My account was overdrawn, and it was actually canceled by the bank. And it's difficult to open these accounts based off of the way that that I own the property. It's not just a normal business account. It's a self-directed real estate 401k bank account. So not many banks will do that. So not only has this caused us financial hardships, it's caused us to lose that account. Now we were able to open another account, but that still doesn't catch us up on the obligations of the tenant to pay us rent and use the property. And
I know, I get that part. Everybody, in case anybody isn't aware, I understand the ultimate conclusion that everybody wants to get to from their respective sides. What I'm trying to figure out is the funds that were paid for, I guess it would have been, it may have been paid in October, but not applied for that month because of first in whatever. It was like 3,300 or something.
30, yeah, and
508.
it was.
So my
paid
question
for November 1st rent. The check was sent for November 1st rent.
No, I am not. Yes, I am not getting into what month that will apply to because I'm not getting it. I'm not going down that rabbit hole. Sir, are those funds, that 3,500, whatever, is it the case you cannot access those monies?
No, I was able to convince Chase to open a new account and deposit that check.
Gotcha. No, it's okay. I just, you knew it. The facts you relayed to me were the facts at a certain point. He's done something else, and so now it's open. Okay, all right.
Also,
Okay, so
Your Honor,
go ahead, sir.
I was never contacted about anything related to electrical outlets or any emergency. I don't understand why they are saying that.
Your Honor, I received an email. I received an email about a repair. I didn't even know Ms. Tope was still representing the tenants. So I think we're past the emergency motion, alleged emergency motion.
Yeah. So here's what I'm going to do to try to make this clear. I'm going to grant the motion to withdraw. I am not going to sign the order that you have indicated. You will prepare an order that it is effective now.
Okay. We can just write it in.
You can do whatever you want to do. I just need something to sign that indicates that you are
Effective immediately.
Immediately.
Yeah. And I'll sit down.
You folks are not in a position to argue anything regarding this right now, are you? Well, one saying yes, one saying no. What?
Oh, I'm just nodding and listening to you. I'm just the rest of your.
So what I'm going to do is this. I'm going to set all the motions for hearing, and the quickest that I can get it done where I can look at everything and give you time to, here it is, January 6th at 11 a.m. So all the currently filed motions, with the exception of the motion, except for the motion to withdraw, which I have ruled on the second time, quite frankly, will be heard on that day.
Okay.
Counsel, with respect to the motions that have been filed by the defendants in this case, how long will it take you to respond to them, those motions?
For me?
For you.
I mean, I can.
Well, let me just do it this way, because it's going to be, I'm going to.
They're non-dispositive motions, so I think under the court rules, I have.
Well, except for the fact that this is a summary proceeding, so the rules kind of.
Okay. Yes.
But I don't want to put anybody behind, I'm not trying to do that. I want to give everybody time to at least get something to me and respond to what's there. Can I get a response? Can you file a response by the 30th?
I will get it done. Yeah.
All right. So now, folks, you've got to respond to their motion, the plaintiff's motion for summary disposition. Are you going to be able to respond by the 30th?
Are you talking about the thing I just saw today?
Yes. Well, I'm assuming the thing you saw today was this.
It is.
Okay, yeah. I mean, I briefly.
Yeah, so yes.
I mean, we just got it at 12:30. And I forwarded it to them by email.
So you can respond by the 30th.
Yes.
All right. I do not need replies to any responses. I will give you time to argue what you need to argue before me. I think I can process it. I just don't need that. I'm also going to direct, at least at this point, that there are to be no other motions filed between now and the time of that hearing. Okay. All right.
I appreciate that, Your Honor. Thank you.
I have a question.
Sure.
And Mr. Etherly has stated that their motion that was received at 12:30 today is dispositive and is essential and needs to be heard. However, the motion to dismiss with prejudice that is filed on behalf of the defendants should be heard first before his motion for summary disposition. That's just a comment because this was filed on Wednesday.
Can I just tell you this? I gave.
You don't care what I say.
Just think about this for a moment. I understand what counsel was indicating to me when he's indicating to me that he wanted that one heard. But his basis for doing that was his belief, and I didn't respond because I don't know, is that that would be dispositive of all of the issues and we would maybe have to deal with that. I get what he was telling me, but he didn't harp the point home and tell me, Judge, you got to hear this one first. I mean, I've set everything for one day. So I really don't need to be told that that motion needs to be addressed. Here's how it's going to work. I've been doing this for a minute up here.
Yeah,
I'm going to hear
or
them
something. Yeah.
the way I'm going to hear them. And even if I hear them what seems to be out of order, I can figure that out as to how to rule on these.
Right.
Everybody okay with that?
No, that's perfect. My only comment was intended to be able to address what Mr. Etherly had said, not any, decisions or anything that you would be making. Here is the order for you to sign.
Has counsel seen it?
I have not seen it.
Oh, you got a copy of that or that?
Well, which changed it. So customarily, you then show it to opposing counsels for see if he has any objection. That's the way it works.
No objection, Your Honor.
Oh.
Thank you.
Okay. I was afraid to ask. Any other questions, comments?
Want to confirm January 6th at 11:30 a.m. Your Honor?
Yes, at 11 a.m. Okay. Responses to all motions are due by close of business on 30th. If I could, and because I'll be trying to take a little bit of time off with the family, if you could get my coordinator's email address so that the judge's copy comes email so that it can get to me wherever I happen to be. All right. We will make sure to provide that to you.
Yes.
All right. Folks, do you have any questions? No? All right. I guess in fairness, you have any other questions?
I have no other questions.
All right. And my last point will be this. I am not ignoring the financial statements that are made by the plaintiff. Although at this time, I'm not prepared to release any of the escrow funds that are held. The court is reserving the right to change that or modify that and may release some of that as it's paid. There is 9,000, looks like 98.25 that is currently in escrow. 96.25 in escrow, and that when we reconvene on the 6th, an additional 5,500 should be
Thank you.
in escrow. All right. Thank you, folks.
Thank you, Your Honor.
Hey. That block? That's it for that block? Oh, yay. All right, court stands in recess.
Yeah. Court stands in recess. Lord have mercy. Well, ladies and gentlemen, Another week, another day in the books, another Friday on top of that. You know what that means? That means in a very short 13 or so hours, we're going to be live again. We'll be live on Saturday morning, 11 a.m., noon Eastern, 11 a.m. Central. Who needs time zones, right? It's all the same time everywhere. It's going to be noon somewhere in the Eastern time zone for sure. For those of you who are having a big freeze out there, stay warm, be weather aware, and thank you for coming out and hanging out at the court gallery this evening and chatting about the court we've been watching all night. Miss Tope, she is a gem. She is a pill. I have to bet that we will see her again. This is not the last time we've seen her. Heck, I don't think it's the last case that she has actually on the docket at some point. We'll see. We'll see. I have it on good authority that there were more interesting things that happened in Simpson today. I just didn't get around to checking all of them because he had an 8-hour docket, ladies and gentlemen. And I have news for you. Simpson wasn't the only busy one. It was the last Friday before, you know what? Christmas Day. So it's going to be a short week next week. I got almost a full show planned for tomorrow. We got a lot of interesting small claim stuff coming out of Washington State. So, you know, Planet Washington, guys. Come on by and hang out, say hi. I'll be here. I'll be looking for you. Don't forget to like and subscribe and do all that stuff that, you know, YouTubers are supposed to talk about. And I'll say thank you very much for coming by. I'm your Lowell Fussell. I am your curator for these here compilations. I'm your host for this here, the Court Gallery on the YouTubes. Y'all have a very good night, and we'll see you next time. I'm out. Peace.
Come by and watch me tomorrow, please. I really want to see it. It really matters.
Again, thank you very much, Wolf Lore Lover. And thank you very much, chat. Tori, good night. Bro Miticus, good night. Mama Wolfie, thank you so very much for hanging out. Doreen Day. There's a lot of people I haven't seen their names in a long time. Flora Punk, Soprano, Big Tiff Dog, Kiernoth, Jojo. What am I saying? Jojo's mom, Dorothy. Dorothy, thank you for coming by. Good Lord. You guys rock. I'm done. There's nothing else to watch here. This is absolutely not some weird Ferris Bueller's Day Off sign off thing. I've never done this type of thing before. You know, I'm definitely not doing it again. Good night, ladies and gentlemen. Good night. I know I didn't get all of you, but y'all matter.